Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 415 of the FCPA Compliance Report. Today, I have with me Michael DeBernardis. He is a partner at Hughes Hubbard & Reed. We're going to talk about the Hughes Hubbard & Reed 2018 FCPA Anti-Corruption Alert. But first, have you ever thought about starting your own podcast? As you probably know, I've founded the Compliance Podcast Network, and I'm always on the lookout for new podcasts. If you wanted a podcast but really didn't know how to start, take a listen from our sponsor today, One Stone Creative.
If you're enjoying this show, you might enjoy hosting your own. As an expert in your field, you have skills, knowledge, and insight that can help you expand your practice, meet new people, and create amazing content to share with the world. In as little as 2 hours a week, you can dramatically change how you promote, fill, and position your business. And One Stone Creative can show you how. Learn more at onestonecreative.net.
We take a look at some of the key Department of Justice FCPA pronouncements from 2018, including the anti-piling on policy, the M&A safe harbor policy, and how to avoid a corporate monitor. We consider some of the key FCPA enforcement actions from 2018, including Petrobras, Credit Suisse, Panasonic, Avionics, and Société Générale. 2018 saw two rare cases at the U.S. Supreme Court impacting the FCPA, Cohen and Hoskins. We consider what they might mean for the compliance practitioner going forward. We consider the final decision in the UK on the ENRC case and what it means around protecting internal investigations. And finally, what does GDPR mean for FCPA and related anti-corruption investigations going forward? It's a fascinating podcast. I know you will enjoy it. This is Tom Fox. I'm the Compliance Evangelist. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back for another episode, and you're in for a real treat today because I have Michael DeBernardis, I hope I got that right, from Hughes Hubbard & Reed, and he's here to talk to me about the firm's 2018 FCPA Anti-Bribery Alert. So, Michael, first of all, welcome, and thank you for taking the time to visit with me.
Sure, Tom. Thanks for having me.
So, Michael, there's been a lot of commentary in 2008 that it may not have been that significant a year in the FCPA, that the numbers may be down and the DOJ may or may not be going in a different direction. But frankly, I found a lot of substance for the compliance practitioner, the private practice lawyers such as yourself, the in-house compliance professional. So I really wanted to use this to really explore what you and the firm are really talking to clients about. So could I start with asking, what is the Hughes Hubbard 2018 FCPA and Anti-Bribery Alert?
Sure, thanks. The alert, it's an annual publication for us that we've been doing now for about 10 years. It's a resource for anti-corruption practitioners, for compliance officers, for other compliance professionals that really tries to, as best we can, summarize and analyze the latest developments in anti-corruption enforcement. While it focuses on, in the first place, on the FCPA, it really is broader than that, and it covers sections on the UK, on France, China, Brazil. There's a section that talks about developments in multilateral development bank sanctions and anti-corruption enforcement, and other international developments. It's over 160 pages, so it's not meant to be a cover-to-cover read, but to really serve as a resource and a place that people that work and are interested in this space can go and hopefully gain a better understanding of what's been going on recently.
So that's one thing I really appreciated about it. It really is hefty and got great substance. And if you want to go into the weeds, you can certainly do that. But you also really lay out near the front of it trends, lessons learned, and how this can be used really by the compliance practitioner. So if I could really start off with some of the things we saw from highlights from 2018. And I think we really have to start in November of 2017 with the FCPA Corporate Enforcement Policy. which was announced. And then moving forward, we had the M&A edition, we had the anti-piling on policy, we had the Binkowski memo, and then at the end of the year, we had some other DOJ pronouncements. But I was wondering if you could really sort of take us through that journey, starting with the FCPA Corporate Enforcement Policy, and where you see either the DOJ changed, whether they really put into writing what the practice was, or maybe even form was following function, if I can use that phrase.
Sure. No, that's a great question, and you're right. We cover each of these topics in the alert, and it's a little odd that we go back to November 2017, but for reasons I won't go into, we're sort of on a November to November schedule with this alert. So the corporate enforcement policy was actually announced in 2017, the day we issued that 2017 alert. So it fit nicely into our 2018 alert for this year. But I think the policies you just mentioned have really been raised questions for a lot of our clients, for a lot of the compliance professionals that we have been dealing with, and they really fit into two buckets, kind of as you referenced. One of them are serious, what we consider to be serious policy changes and departures from the practice of the Department of Justice. The other bucket would be policies that maybe clarify or formalize what was already the practice. So the corporate enforcement policy, which to us is highlighted in the alert, was one of the major developments in the anti-corruption space over the last 12, 15 months. It formalized or made permanent, if you will, the pilot program from 2016, but which was a major change, right? This is a change in how companies should approach internal investigations and approach the Department of Justice, because it really makes the calculus as to whether to voluntarily disclose a potential FCPA violation, it moves the needle on it. The benefits of voluntary disclosure are more clearly laid out in the corporate enforcement policy than maybe they were in the description of the pilot program. And the carrot of a declination and the presumption that a declination would apply if you voluntarily disclose and take the other additional steps is one that has certainly garnered the attention of our clients. And so we're getting a lot of questions on that one, and we've seen it play out now over the course of 2018 with a few declinations. I think from our side, we're still waiting to see how the Department of Justice may approach a case that is a little of a larger scale, sort of some higher value or larger scale bribery that's voluntarily disclosed, whether they'll be as willing to issue a declination in that circumstance. But so far, it certainly is giving clients something to think about and consider. It as we tell our clients and companies often is what it really does is put pressure and really added importance on responding to allegations of misconduct early, so that you can kind of determine what happened and really have all your options on the table. The piling on policy, as you mentioned, is more of the first bucket. If you look back at large resolutions over the last 2 or 3 years in the FCPA space, particularly resolutions that involve multiple jurisdictions, you see an effort by the Department of Justice to allocate penalties and to sort of split fines, if you will. They'll use the Department of Justice's calculations, but then the fines will be split up so as not to double or triple penalize offenders. And really the piling on policy just makes that formal. The department will seek to work with both domestic enforcement agencies and where possible with other foreign regulators to come up with a resolution that makes sense and to ensure that companies aren't being double and triple penalized. And the same thing with the more recent changes to the Yates memo in terms of individual prosecutions. In our experience, the department has not been strictly following the Yates memo in terms of making sure that companies identify every single employee that may have potentially been involved in the misconduct, and instead has been focusing more on who was substantially involved in this misconduct, particularly at a senior level, but throughout the company. And that's really, as a practical matter, the only way to do it. It can become extremely difficult, as you can imagine, to run an investigation, all the way to the ground to find out every potential employee who could have possibly been involved before reaching an agreement with the government. So that one I put in the bucket of sort of formalizing what they were already doing. And I think in announcing that policy, the Department of Justice even recognized that the change was really to reflect current practices more than to make any major policy changes.
So you really said something that struck me, Michael, in a phrase that I really had not heard before, but I'd like to go back to it. And you said that the corporate enforcement policy and the policies coming forward through 2018 move the needle on the decision to self-disclose. Mm-hmm. And what struck me is a couple of things. One, that's a great metaphor. But two, the decision to self-disclose in many ways, I think, is one of the most difficult decisions that a board of directors, a senior management, or whoever in an organization has to make. And having someone like yourself and Hughes Hubbard counseling on these decisions with this new information by the government seems to me, the way you laid it out, is that you can now tell a client, or at least counsel them, that this is what the government says, that you will receive substantial tangible benefits that we can point to. Would that be a fair assessment?
Absolutely. Having it in writing and more firm than the pilot program had sort of laid it out is incredibly helpful when having those discussions, and really incredibly helpful for, as you mentioned, a board of directors or senior management when they're trying to make this very difficult decision, possibly the most difficult decision there is in this context. As I mentioned, I think where the pressure comes in now is responding quickly and thoroughly to the allegations of misconduct when they come through, because it's not until you really understand what happened until you can make these difficult self-disclosure decisions. And now the pressure is on to make those to make that finding as quickly as possible, so that you still have the option to disclose it before it leaks out or the government finds out on it on their own. But with the guidance in the corporate enforcement policy now, we're able to really go into some detail. There's no guarantees in this space, but we can go into some detail and really lay out the probabilities of different outcomes for companies in order for them to make a decision regarding self-disclosure.
So the next area I'd like to turn to is we had really some massive cases last year. They may have skewed the overall numbers. Nevertheless, they were massive, and they had some very interesting aspects. And I was wondering if we might be able to visit about some of the key cases identified in the FCPA and Anti-Bribery Alert. And they're a lot of fun to talk about. So could we just maybe start with Petrobras? And sort of what were your thoughts around this?
Well, Petrobras, I think, is the headliner for 2018, both in terms of size, for sure. The global settlement, I think, reached almost $1.8 billion. but it was also just really fascinating from beginning to end for a number of reasons to me. At the end of the day, the Petrobras case, when you sort of look at it, and if you think of it from a 30,000-foot view for what it is, you can make the case credibly that Petrobras as an entity was the victim, right? The allegations are that employees at Petrobras for years and years and years took bribes and paid off politicians to help them keep their positions within the company. So in a lot of ways, the company itself was a victim. Now, that's probably why the charges were not focused on anti-bribery, but rather books and records and internal controls. And certainly, when you look at the facts of the case, the internal controls were over a period of many, many years lacking at Petrobras and led to this pervasive corruption that has now not only ensnared Petrobras, but as you know, over the course of the last few years, has covered a large number of both Brazilian and international companies operating in Brazil. But it's really unique that the entity that is accused of taking the bribes is now facing an FCPA, or faced an FCPA case, which is just really interesting.
But we also had a couple of other cases that you highlighted. Credit Suisse really talked to us once again about the hiring of sons and daughters and family members of foreign government officials. But here it had really the rather unique aspect to Credit Suisse not only targeted, but tracked the profitability of hiring these sons and daughters, which I had not seen previously. But leaving that aside, do you feel that I often tell to clients that you can hire a son and daughter? It's high risk, but simply because it's a risk doesn't mean you can't do it. Or do you think these cases take us in a different direction?
No, I agree with you, Tom. I think it is hiring a relative of a public official is a high risk transaction, but it's not prohibited per se, and I think there's a analysis that needs to be done and an assessment of those risks that needs to happen. Credit Suisse, has pretty clear evidence from the facts that the employees were being hired, that candidates were being hired strictly because of their relationships with their family relationships with important government officials. And as you mentioned, they even track the profitability of these various hires. They also, the pretty clear facts that the candidates that were hired were not qualified for the positions that they had and were retained despite really poor performance records. But we've certainly dealt with clients in the past, operating in some jurisdictions where it's very difficult to find a qualified candidate who is not related to a government official in one way or another. And really, if you put a strict prohibition on hiring relatives of government officials, it would be really difficult to find local talent that you could hire. So, we put a lot of emphasis on making sure that clients have a process to evaluate candidates to ensure that they're actually qualified for the position, to make sure that they are considered the same as candidates who do not have this important familial relationship. And to make sure that they're compensated based on their qualifications in the market rather than some other factor. So I think the Credit Suisse case is really on one end of what is an important spectrum in terms of hiring relatives of government officials.
The Panasonic Avionics case was just fascinating to me. Literally, corruption at the top of the organization. We had CFO and CEO involvement in the bribery scheme, but frankly, a lot of very interesting lessons learned, I thought, certainly around discretionary funds available to a CEO, override of internal controls, and then the use of or ongoing due diligence between the times that a company would renew or hire a third party. Were there any aspects of this case that you really not only thought were interesting, but have tried to emphasize to clients?
For sure. The Panasonic case has become a favorite of ours for training purposes, because it's sort of chock full of lessons to be learned. But one of them that we often talk about is, it's really interesting in the charging documents. They talk about the relationship with some of the key agents started back in the 1980s. And when we are helping companies put in place due diligence procedures, one of the pushbacks we often get is when we suggest look back exercises. So this can't just be a forward looking exercise for new agents or representatives, but you really need to go back and due diligence on your existing representatives. And the business people often will push back and say, why do we need to do diligence on entities that we've been working with for 30 years, 20 years, whatever it is? And I think this case illustrates perfectly well why that's necessary. So that's one really interesting piece of it. The other thing, and this is really a theme I think that we saw throughout 2018, and certainly we try to highlight in the alert, is Panasonic did, as you mentioned, they did have ultimately a due diligence process put in place. And so it's not like at the end of the day they were operating completely without any type of process. They were really criticized for, one, not taking the process seriously, making it very rigorous, and two, for putting individuals, employees in charge of the process that lacked qualifications and training on assessing red flags involved in representatives. And so it just really emphasizes to me the importance of ensuring that you have the right people in place. There is a skill involved, as you know, to assessing and evaluating red flags when it comes to third parties. It's a skill that can be learned through training, but it's a skill nonetheless. And so you can't just throw anybody in there and hope that they can run your due diligence program. And then, the last piece that we've taken and really been able to use in trainings and that type of thing, discussions with clients, is one of the fact patterns involved in this case involved the company engaging a former government official, negotiating with that individual while he was a government official, looking at their contract, and then hiring him after he resigned from the government shortly thereafter. And when we advise companies that they should really take a close look at hiring former government officials, we sometimes get pushback about why, where the risk lies with somebody who's no longer a government official. And I think this just highlights it well. This is really the main risk, is that a business person promised him or her something while they were still a government official. And so you have to look at those situations closely.
And then Société Générale, several things really intrigued me about this case. And one of those is the sovereign wealth fund issue. We have had previous sovereign wealth fund cases, FCPA enforcement actions, I should say. But this case, I've really used it as a teaching moment for companies that may be looking to sovereign wealth funds for an infusion of capital. whether that be a stock purchase, whether that be a private equity investment, or something else. So lots of interest in this case, certainly in the energy sector. But how do you see Société Générale, or perhaps I should say, how do you guys use it as a teachable moment?
Sure. No, I think you hit the nail on the head with the sovereign wealth fund issue. I mean, it wasn't that long ago that OCSIF reached its resolution, and part of those facts involved their interactions with the LIA, the Libyan Investment Authority, the same one that's involved with Société Générale. So, the reality is, typically transactions with these sovereign wealth funds, more and more, are really large transactions, huge dollar values, a lot at stake. And so there's just that opportunity and temptation when you're dealing with values that high for nefarious action. If you've paid any attention to the allegations surrounding the 1MDB scandal in Malaysia, we're seeing some of the same type of allegations with when you're talking about single transactions that can earn you a profit in the hundreds of millions of dollars. The temptation for a corrupt payment here or there is very real. The other thing I think, very simply from the perspective of SocGen that we think is important, is the involvement of the French authorities, the PNF. This is the first FCPA case that they had, joint resolution, joint settlement. So I think it does send a signal. I think we anticipate more and more enforcement by the French authorities and more cooperation with the U.S. in terms of settlements. And it's something we're really looking towards in 2019 and beyond.
I must stop you there and congratulate you. You're the only other person I know who uses the word nefarious. So well done.
Thank you.
We had a couple of court cases over the past year, and those certainly are not common in the FCPA space. You want to talk to us about both Cohen and Hoskins and what you think they might mean going forward?
Yeah, that's it's always exciting in this space when there's a court case, because as you mentioned, they're rare. So it's possible that we give them too much attention because they are so rare. But both the Cohen decision and the Hoskins decision, I think, are interesting for their possibilities. It's a bit of a wait and see game for both. Cohen, the big takeaway in SEC v. Cohen is that the 5-year statute of limitations that applies to the SEC implies to certain types of injunctive relief. Slowly over the last several years, the courts have been chipping away at the SEC's tools for enforcement in terms of how the statute of limitations applies. And they've already decided that it applies to civil penalties, to disgorgement, to declaratory relief, and sort of injunctive relief was hanging out there as maybe the last piece that the strict 5-year statute of limitations did not apply to, and Cohen suggests that it does. So if this other courts take the same position, I think it has the possibility to really limit the SEC's ability to look back at historic conduct. And as we know and have learned, often in the FCPA circumstances, it takes a while for the allegations and the conduct to come to light, and so that can really possibly hamper the SEC's ability to get at some of these FCPA cases. The Hoskins case in the Second Circuit is also very interesting for its possibilities. I think at the end of the day, all that the Hoskins decision may do is just put a little bit of an extra burden on prosecutors in terms of proving that the defendant was an agent of a domestic concern or an issuer, but essentially Hoskins decided that prosecutors cannot use conspiracy or aiding and abetting theories to charge FCPA violations to individuals who otherwise would be outside of the jurisdiction. So Mr. Hoskins was a foreign national, did not come to the U.S., so he was not a domestic concern. Obviously, he wasn't an issuer himself, and he did not take any action in furtherance of the scheme while he was in the U.S., so he wasn't charged under 78 DD3. So instead, he was charged under a conspiracy theory that he conspired with an issuer or a domestic concern, being the Alstom U.S. entity, and aiding and abetting, that he aided and abetted a domestic concern. And the Second Circuit said that that's not, you can't use those theories to apply jurisdiction where it would not otherwise have applied. At the end of the day, the court was clear that he could still be charged as an agent of a domestic concern or an issuer, even if he didn't take any actions in the U.S. So, it just means that the prosecutors have to take those extra steps of proving that the defendant, Hoskins in this case, was actually acting as the agent of the domestic concern or issuer. So it may not be a huge change, but in the past, we've seen cases in the past where companies or individuals have settled on the theory, these aiding, abetting, and conspiracy theories, where jurisdiction otherwise would not have existed. The one that comes to mind for me is the Japanese company JGC, which was part of the TSKJ joint venture back several years ago, 2009 or so, that I believe was settled a case entirely on conspiracy and aiding and abetting jurisdiction in terms of their cooperation and work with domestic concerns, including with KBR and Technip, who was an issuer at the time. So, it'd be interesting to see if companies are more willing to sort of challenge the DOJ.
Michael, we had a couple of developments outside the United States that certainly will impact not only FCPA enforcement and investigations, but the broader anti-corruption investigations and enforcement. And I wanted to perhaps end our podcast on these two matters. The first is the ENRC matter. What did you guys see around that case?
Well, I think we breathed a sigh of relief, as did many other practitioners in this space, as it all was restored to normal. There was the 2017 decision in the UK that basically said that privilege may not apply to attorneys' communications with clients during the course of an internal investigation, and that things like interview notes may not be privileged. Really, I think sent shockwaves through investigations attorneys, regardless of where they were practicing. So for a good 12 months there or so, there was a lot of worry as to how the whole thing would shake out, because clients really rely on that privilege. Attorneys really rely on that privilege to help really get all the facts out. I know that there's a fear that it would really hamper the ability of clients and attorneys to get to the heart of a matter if the discussion wasn't covered by privilege. So with the decision of the Court of Appeal in 2018, I think it might have been May, kind of restoring back the litigation privilege to conversations and during the course of investigations, particularly when there's fear of a criminal investigation following. Really, I think it was widely applauded by the legal community.
And then everyone's favorite GDPR. I get to pontificate, but probably just actually speculate on this case a lot. But what are you guys actually trying to counsel clients on around the greater anti-corruption enforcement and investigation space?
Yeah, just caution. I think more than anything else, there were already blocking statutes in place that made investigations and e-discovery in the course of investigations a little more complicated. And GDPR, I think, just adds to that, where we used to really feel comfortable with getting waivers. There's thoughts about whether that's going to be enough anymore. And so really just caution and documentation are the two things that we tell clients repeatedly. We really want to document the reasons for data collection and how data has been maintained and protected. Really, I think for Hughes Hubbard certainly, and I think for most of other firms, we've gotten sophisticated enough with our processes that we're comfortable that we'll be within the limits of the GDPR when we conduct our investigations on behalf of clients. I think what we've been trying to do is to educate clients on these requirements so that when they're doing internal investigations on their own, smaller matters or whatnot, that they're very careful to make sure that they are sort of applying the same standards.
Well, Michael, unfortunately, we're near the end of our time, but this has just been a fascinating exploration of where we were where we were in 2018, but equally importantly, where we may be going in 2019. I wanted to thank you again for taking the time to visit with me today.
It was my pleasure, Tom. Thanks for having me.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. I've linked to the Hughes Hubbard 2018 FCPA and Anti-Corruption Report in the show notes. Check it out. It's a fabulous resource, not only for 2018, but going back further into FCPA enforcement and guidance from the law firm. If you have any questions, you can email me at tfox@tfoxlaw.com. I hope you'll join me again next week where I have James Koukios. James is a partner at Morrison & Forrester, and he comes back for the always fan favorite monthly International Anti-Corruption Report the firm put out for December 2018. This is Tom Fox. I hope you'll join me again for another episode of the FCPA Compliance Report. The FCPA Compliance Report is a part of the Compliance Podcast Network.